Okay, good morning. This is attorney Catherine Hedgeman, and I wanted to thank all of you for signing up to attend this presentation. I really enjoy giving this presentation as an informational to people because I want to make sure that, either my potential clients or people out there that are contemplating starting a nonprofit realize what goes into it and what a responsibility it is. So without further ado, we'll get going on the presentation. I do have the Q&A open. So if you have a question while we're doing the presentation, you certainly can write it in the Q&A and I will attempt to review it and answer it. If we don't get a chance during the presentation and you want to reach out to me directly, you can certainly do that as well. Okay. So the first thing I always tell a potential client when they call me about starting a nonprofit is it is not a hobby. And what I mean by that is there's an extensive amount of financial and legal responsibility that goes along with operating and governing a nonprofit, especially in New York. And it's very similar in the District of Columbia as well, which is another place that I practice. But overall, no matter what state you're in, the non-for-profit laws are fairly stringent and compliance is usually very burdensome especially for a startup nonprofit that's run by all volunteers. That's not to say it's not doable, but oftentimes, and especially lately, I've been getting the calls for just the opposite. We're a volunteer all-run nonprofit and we need to dissolve because we just cannot keep up with the compliance and operating in a way that's responsible. So it's interesting. I think COVID really put an idea in folks' head to, think about what it is they're doing and if there's another way to do it other than starting a nonprofit. And there certainly is a lot of alternatives to starting your own nonprofit. You certainly could work with an existing nonprofit as a fiscal agent and run a program through an existing nonprofit where they collect the charitable dollars for you under their charitable registration. You also might just consider going to the community foundation in your community and asking them to be a fiscal sponsor if that makes sense for your organizations. I know a lot of memorial scholarships and different things go through the community foundation in different communities simply because it is quite a burden to run a nonprofit and to award scholarships for a group of volunteers. So today, what I hope you take away from the presentation is not only the laws that govern nonprofits, especially during the startup phase, but also some of the compliance that goes along with it, and certainly the steps for setting up a nonprofit. So in particular, if we talk about New York, and the DC Act is very much the same. In 2014 in New York, the Attorney General's office, in partnership with the New York State Legislature, overhauled the non-for-profit laws. And what that meant is it really brought non-for-profit governance into the 20th century. I can talk a little bit about what I mean by that as we move, through the program. But there was a lot of law on the books that no longer made sense. For example, noticing meetings by regular mail or taking email votes. For at least a decade, I can think of many of my clients that thought it was okay to take an email vote when the law really didn't provide for that. And essentially what that means is, the vote that you took is null and void. So in 2014, and that again, that's a subject of another webinar that I do on just the legal fiduciary duties. But In 2014, the law significantly changed to allow certain things to be done by email, but there's a certain way you have to do it. And also to have a video or teleconference meeting. Before 2014, that was really not permissible. So more on that later, but the New York not-for-profit law governs New York's that are or nonprofits that are incorporated in New York. And if you're incorporated in a different state and you want to have a nonprofit do business in New York, you have to be registered in New York as a foreign nonprofit corporation. And if you don't do that, you can get in a lot of trouble. That goes the same for if you form a nonprofit in New York, but maybe you want to solicit funds in New Jersey, or maybe you own a piece of property, a camp or something in Vermont. You have to be registered pretty much in every state that you're doing business, and there's a doing business test for that. Other laws that govern nonprofits, especially at the startup phase, are federal tax law and regulations. The Attorney General's office in each state is the primary state regulator for nonprofits, as well as the Secretary of State in states as well, who receives the corporate filings of the organization. So one of the things that I like to say early on, and I always get the call from a potential client saying, we'd like to start up a nonprofit. What is there to it? What are the legal fees? What are the filing fees? All of that. And by the time we get through that, the person generally shies away from it because of the cost and thinks that they can set the nonprofit up by themselves. I don't want to sound biased, but I've also received those calls later on. I tried to do this myself, and the New York Secretary of State sent it back, or the IRS told me they're not approving my application. So what I'm saying here is you really do need to seek counsel early, and to at least talk about the pitfalls of not using an attorney. The IRS and the attorneys that work with the IRS on startup applications or mergers and dissolutions, which I also do a lot of, they have a good relationship with the IRS and the Attorney General's office. And so there's some credibility when your attorney does submit those applications for you versus, the founder usually is the person that's, submitting those filings. So, definitely something to think about. I've done this for so long that some of what I'll say today, isn't necessarily legal, but definitely something that you need to think about when you're starting up. And I thoroughly recommend that you have at least $10,000 to $15,000 in hand to start up the nonprofit. And you can raise that through volunteers. And there certainly is a way that you have to keep that money in a segregated bank account and, have that available for your startup funds. And the reason for that is not only should you seek counsel, but you're going to need a financial consultant to set up your financial systems. You're also going to need the filing fees for the state of New York and the IRS, and those alone could run up to $2,500. So the first step in New York, very similar in most states, is you need to file your, actually it says articles of incorporation. It should say certificate of incorporation. That's what New York calls it, with the Secretary of State. And this is the juncture that if they hadn't called me about incorporation to begin with, a potential client calls and says, I pulled the form offline and I filled out the blanks and I submitted it to the Secretary of State, and they sent it back and they said, no go. Why is that? Well, in certain circumstances, there could be a number of reasons why they bounce it. The big one is most people who are not attorneys don't realize that there needs to be very specific language in the certificate of incorporation regarding dissolution of the corporation and what happens to the assets when the corporation is dissolved. It also has to make a statement that it is going to be charitable and no benefit will inure to the board of directors. If it's an educational nonprofit and you're trying to get tax exempt status for a 501c3 on the basis that you're going to offer educational programming, the New York State Department of Ed has to review this certificate of incorporation and determine that you're not a school and you're not under their jurisdiction. So before you can even file, you need to get a certificate from the New York State Department of Ed. So that's just one example. You may need approval from other organizations, state-led agencies, things like that, the typical volunteer starting a nonprofit would not know they would need that. So something to think about there. In New York, the filing fee for a nonprofit certificate of incorporation is still at $75, I believe. And each time you attempt to file it, if they bounce it back, they keep your money. So it can get expensive if you don't quite know what you're doing. The next step after filing your certificate of incorporation, and mind you, you may have at that point what we call a New York State not-for-profit corporation. You do not have tax exempt status at that point. And that's really what you're going for here. So what that means is at that time, you're preparing to submit your IRS tax exempt application to the IRS. And ultimately, when they approve your tax exempt status, all the income that you've had back to the date of the filing of the certificate of incorporation is tax exempt. So they give you retroactive tax exempt back to that date. So that's why a lot of times people can incorporate, raise the startup funds, because ultimately they should be tax exempt, and use those startup funds to move the organization forward. Once you have that, the second step really is to hold your first meeting to elect the board of directors, and also to begin to approve certain policies you're required by law to have. Also at that first meeting, whoever is sort of organizing the application should go to the irs.gov, or your attorney can do it, to get a federal EIN number. It's the quote unquote employee identification number for the nonprofit. It's like a nonprofit social security number. And you're going to need that because when you go to open a bank account, you're going to open the bank account in the name of the new nonprofit with that federal EIN number. You're also going to need a borrowing resolution, or excuse me, a banking resolution that the bank is going to want to see when you held your first meeting, that the person opening the account is authorized to open that bank account. Again, that resolution has to have very specific legal language in it so that the bank will take it. At that first meeting, hopefully by then, you've decided if you're going to have officers, and generally speaking, most nonprofits have president, vice president, secretaries, and treasurers for their executive committee. That's a good place to start. So what you would do first is elect anybody who was going to be on the board, and also then elect those officers. You may also be in a position at that first meeting to approve your bylaws. And the bylaws in New York have become a significant document because of the changes in 2014 and all of the legal requirements and language that's supposed to be in there. Additional language is also needed if you're a membership organization as well. That's a little bit of a different kind of tax exempt organization, and there's 4 more sections of the nonprofit law that cover just membership organizations. So again, it's important to draft the bylaws in compliance not only with your state, but if you're going to operate in multiple jurisdictions, you're going to have to make sure that overall all your policies and procedures meet the requirements of every jurisdiction. And the reason why at that first meeting, it's good to have the bylaws ready and to be moving on those is you're going to need to submit those to the IRS with your application. So they really do have to be done upfront. The next set of policies, and many times, we have these all ready to go. So at the first meeting, you're adopting pretty much everything that you would need for your organization, at least to get started. That's not to say there isn't additional policies that you're going to need, but we'll talk about that in more detail in a little bit. One of those is a document retention policy. New York has their own document retention laws and requirements, as they specifically refer to nonprofits. In addition to that, document retention policies need to be updated to, this digital age that we're living in. So they must include e-documents. And it's really important in an all volunteer startup. How are you going to retain these documents? Who is going to house them? Is it your secretary? Is there an intraweb or someplace you're going to post everything? Definitely something to think about. By law in New York and in most jurisdictions, you need a conflict of interest policy. New York is very specific with the language that needs to be in there and the duties of the entire board with regard to conflicts of interest and what they call related party transactions. Again, a lot of this I go into much more detail when I talk about just the legal fiduciaries of board members. And what's required of those policies. That's a different presentation, but you're supposed to have these policies in place, again, because they're all going to become part of your application to the IRS, and they are going to scrutinize them to make sure that they're in compliance with your state's law. What that means is, no, you can't pull a form off the internet because you Googled it and say, hey, let's use this as a conflict of interest policy. It looks good. Never recommend doing that, but especially in New York, when the statute pretty much lays out everything that needs to be in there and what needs to be said and the procedure for reviewing a conflict of interest for that board. Some organizations immediately adopt a code of ethics. There's a lot of reasons for that, especially as of late with, different types of people on the board and, setting that standard for board service and what, the board deems to be ethical behaviors. I always recommend it. It isn't something that the IRS is going to require to approve your application, but it's very important. It covers such things as, conflicts and also confidentiality. A lot of times it will address discrimination in the general sense that, the board doesn't tolerate that and board members are expected to act in a certain way when it comes to potential discrimination. In New York now, our famous governor, Andrew Cuomo, put out with the legislature, obviously, all these requirements around sexual harassment training and policies. The board of directors of the organization has to have a policy as well. It can be similar to or in connection with the policy of the organization itself. But most non-for-profits that are startups really don't have any staff. It's really volunteer board. So that's why my focus here is on, the board adopting the sexual harassment policy, which is a New York requirement. And of course, everybody having to go through the training. And again, the policy is also something that, needs to be drafted by someone with the legal knowledge to put that together for you. So as you can see, just based on this slide alone, it can be daunting if you try to do some of this stuff yourself. It's probably, nearly impossible. People do attempt to do it, But a lot of times it's bare bones and it's non-compliant, and they kind of squeak by, by the skin of their teeth. But then when they get to register with the Attorney General and are subject to audit, things turn up later that weren't done correctly. In addition to the sort of the legal requirements for setup, you definitely need to have some volunteers, at least at the beginning, who have a clue about setting up financial systems. You need a good set of books because you're dealing with corporate money, right? You also need to record in those books any restricted donations, or assets. So it's very important that if a CPA or an accountant or a CFO type person is not on your board, that you at least have some volunteers you're working with that can help you set up your, QuickBooks or whatever you're going to use to keep the books of the organization. From a governance perspective and the legal requirements of New York State, you have to have an internal controls policy. That's also an IRS recommendation. And what that basically is it lays out how how the organization is going to operate financially and prevent fraud. So an internal control, an example of that is, let's say you have 5 volunteers that set up an organization. Sometimes it's the president or, the chair or whatever you're calling it at that time, has not only deposit powers, but they can write checks, make expenses, and maybe they're even making the entries into the bookkeeping system. That's a problem because it's one person doing everything. So the internal controls policy splits those duties and balances it out among several people, or in certain instances among certain departments. I'm sure you've heard on TV or read in the paper at some point about, whether it's an ambulance company or a little league, all of a sudden their treasurer is going to jail for a year because $100,000 is missing and they embezzled it. Well, why is that? Well, the board did not have proper oversight. There was no internal controls operations, much less a policy, and nobody was watching the store. And because of that, money was stolen that was donated to the organization. And we'll talk about board member liability in a little bit, but you're a bunch of volunteers that just set up an organization and someone has, converted funds to their own use. Now you've got legal liability. We'll talk about insuring against that legal liability in a bit, but finance piece of all this is very, very important. Also, the IRS requires the internal controls as well for obvious reasons. Finance policies, you really do want to lay out, in a finance policy, sort of some of the ways you're going to do business, right? So if there's an expenditure, some clients do a dual signing of a check, for example. So if there's a signature needed on a check over a certain amount, you have to have 2 people sign off on that, right? The finance policy also dictates, when the board might review the actual bank statements. One of my biggest pet peeves is the financials you're giving at the board meeting every month from your bookkeeping. And okay, numbers look great. We've got X dollars, or we don't have X dollars, whatever the case may be. We spent it on X, Y, and Z. How do you know? Without reviewing the bank statements, I mean, there could be no cash in the bank and somebody made these statements up. So again, part of, the board member, and when we get to committees, we'll talk a little bit about the role of the finance committee. But again, board member liability there. If you have investments or an endowment or plan to, you will need an investment policy. And that sort of sets forth, how you're going to invest your funds and how and when you can tap those funds for operational or charitable use. And in New York, there's an overlay for that. It's the New York Prudent Investment or Management Investment Act that basically tells you what the guidelines are for investing funds and tapping your endowment. And with COVID-19, it's become even more important because folks are tapping endowments when they really shouldn't be. There's no ability to do that. So MIFA has become really popular, and people saying, what the heck is that? How did we violate it? So that's been an interesting 6 months, with regard to investments and needing capital, and a lot of nonprofits finding out they really can't access their endowment, or if they do, the AG has audited them and they did it improperly. So that's another piece of potential liability for board members. So the statutes in New York require certain committees of the board. Generally speaking, most non-for-profits in New York have officers. They have an executive committee. There is a chairperson model that sort of has gone by the wayside with the old law, where you could just have a chair of the board. Now the law has been rewritten so that officers have sort of taken that role, so it's not just one person with all the power to govern the organization. Finance committee, obviously that's a big one. You want people on that committee with some know-how that are paying attention to the operations and the finance of the organization, at least on a weekly basis. Audit committee, which some organizations will say to me, well, the finance committee is the audit committee, or we don't have an audit committee. Surprise, surprise, in 2014, it's now required since 2014, and the finance committee should never be the same as the audit committee. And the reason for that is the audit committee is responsible for auditing annually the books and records of the organization. And even if you're not a huge organization, even in a startup phase, you may want to consider at the end of the year, in conjunction with filing your tax documents, which we'll also talk about a little bit later, having an actual review of your books by an outside auditor to show that you're legitimately using public funds. That expense could be anywhere from $5,000 to $15,000 annually right there. So just to give you an idea, going back to my first statement, forming a nonprofit, not a hobby, you have to have some real funds behind you and some real professionals, CPAs, lawyers, investment managers, if that applies, some great volunteers that, have a finance background. You really need all of that to make it a success. And even then, it's exhausting. The audit committee can't be the finance committee, because the function of the finance committee is to oversee day-to-day operations and finance of the organization. So the audit committee really oversees that, right? And they have to be what New York calls independent members, meaning they can't be involved in the day-to-day management. They can't have an interest in the financial outcome of the organization. A lot of times, nonprofits will put their CFO on the audit committee, and they're a paid employee, and they're also in charge of, the finance function. Not a good idea. Actually, it's prohibited. They're an interested person, and the audit committee has to be made up of disinterested people. I always add governance as the fourth required committee. By law, it's not, but I put it in there because over time and annually every year, you really should assess the governance of the organization and whether you need to update policies, including your bylaws, or whether everything is going, smoothly. At least you can say, we took a look at this to make sure we didn't need any updates or to add different policies on different things. And we're satisfied as a board that, we don't need to do that. And of course, you want to have minutes from a governance committee meeting talking about all of that. One more thing on audit that I forgot to mention, since 2014, the legislature actually legislated into being the requirement for an audit committee. And you heard me mention a few minutes ago, some organizations will say, well, we don't have one. We don't need to do an audit. We're not required by law to do an audit because we only have, a budget of $250,000 or whatever the case may be. By law, you actually do need to have an audit committee. And that's where, pursuant to your conflict of interest policy that we discussed earlier, all the disclosures and or complaints for conflicts of interest go to the audit committee. So again, that audit committee is sitting in oversight to the governance of the board. So the audit committee will walk through, examining the potential conflict of interest. They'll walk through the procedure and then they'll make recommendations to the board. So, you may never have a conflict of interest for a board member come up, but if you do, you're supposed to have an audit committee that exists to be able to send that to. The other recommendation I always have for, governance documents is committee charters, a description of each committee that you have and what they do, so that when you're recruiting people, they kind of know what the committee does to determine if they, like to sit on that committee or volunteer for you. Other committees that aren't required that a lot of nonprofits have, obviously, are fundraising, membership, I'm trying to think, marketing. But one thing, again, since 2014, that you have to keep in mind, and especially if you're a small startup with only a few board members, by law, you have to have 3 board members on every committee you have. So yes, there can be some overlap, but if you think about that and you've started an organization and you only have 5 board members, well, those 3 top committees right there is going to be a pretty big burden for that small board. So you really need to consider, in your bylaws and in your discussions, how large do you think you want, the board to be? And that's also going to determine your voting, quorums and requirements that you're required to have to pass anything for your board. Let's see. All right, so we got past sort of what I call, the beginning steps of setting up a nonprofit organization. And at some point, you're going to, if you want to apply for 501c3 status, which is charitable organizations, there are certain requirements you have to meet to be able to incorporate and receive tax exempt status under 501c3. But believe it or not, there's 501c4s, 5s, 6s, 7s, 8s. It goes up, I think, to 13 at this point. 501c4s are generally, I think, is that the Chambers of Commerce? I'm trying to remember. They're not charitable organizations where they receive most of their donations from the public, but rather have a narrower purpose and are formed like a business league type of thing. I wanted to say, I think, because they changed the sections, it's a 501c6. 501c4s could be the political action committees. And that's another thing, if you want to keep your tax exempt status, you can't be lobbying or supporting political campaigns when you have 501c3 status. And that's why a lot of organizations will form their own separate PAC to support political candidates. It's still a tax exempt entity, but it's not formed under 501c3. Again, I don't want to get too in the weeds, with you on that, but, just putting all of this out there for you to think about. So the federal Form 1023, for the most part, the IRS has tried to make it fairly easy to submit that form. There's 2 now. There's an easy form and there's the long form. And pretty much what the IRS has said is if you are really not going to ever have a budget or income and expenses over $50,000 per year, you can fill out the federal Form 1023 EZ, a short form, And, that'll be good enough. Generally speaking, though, if you really are going to grow an organization, 50,000 is not a lot. These are really, really small organizations. So I always recommend the long form because it can't hurt, especially if you're consistently going over that 50,000 and you're filing the tax returns for the organization. The IRS can see that. And so it's going to probably open you up to an audit and them making you fill out the 1023 long form at some point anyway. So the federal 1023 form really is the application for tax exempt status. And it does collect a lot of corporate information. But what's really important to know is you're going to need a written statement of all the activities that you're going to do under the organization. And it really needs to focus on that qualifying factor. And under the 501c3 of the actual tax code, it walks you through the different types of charitable activity that will qualify. One is educational, one is scientific. There's different, qualifications, I guess is the best word, of the organization to receive tax exempt status under 501c3. In addition to that, the IRS is going to want all those policies that we've just discussed. It's part of their application. Not only is it good governance, but it's part of the application. Specific scrutiny given to bylaws, conflict of interest policies, and document retention policies. You're also going to need minimum 3-year projected budgets, and there's very specific forms in the 1023 application for you to give them a budget the way they're asking for it. So, that's definitely something that, you're going to want to have somebody help you with, hopefully one of your financial volunteers. Okay, so let's say everything goes well with your tax exempt status application. Realistically, especially with COVID, you're probably looking 6 to 9 months for the IRS to even approve it. A lot of times they come back with questions and need additional information on your activities or, perhaps on some of your numbers or even some of the language in your policies. It really depends, what issue there is. They'll generally communicate with you by mail. They'll never call you. And so you'll get a letter and they'll ask you to submit more information pursuant to that letter. But once you do get the Holy Grail, which is a letter from the IRS that says you are granted tax exempt status, here is your letter stating that, you are now tax exempt as far as the IRS is concerned. That is not the end of your process, unfortunately. Now you have to take that federal letter that you received and fill out the New York State application for tax exempt status. And, pretty much at that point, if the feds are going to give you the status, New York will. But it's their way, and it's the tax department's way in New York and or DC or whatever your state, is to see who is doing business in New York and to make sure that they're not taxable. And the state, once they approve, and there's a filing fee for that too, I forget what it is, but once the state approves your application, they will actually give you a tax exempt card in the mail. And that is a New York State tax exempt number. And so what that does is when you buy things either online or supplies or whatever you need for your particular nonprofit, you won't pay sales tax on that. So getting that card from New York State and getting the New York approval too for tax exempt status is very important. You're also going to have to probably file an exemption from franchise tax as well, because there's a lot of income taxes and payroll taxes and different things in the state of New York in particular, and most other states it's the same way. you're only exempt from some of those. So the State Department, wants you to fill out a form for those that are that you'd be exempt from. And then the others, obviously you would have to pay. I don't believe nonprofits are exempt from payroll tax, just by example. But you are exempt from sales tax and real property taxes as long as the property you own is being used for the exempt purpose. And that's a tricky question, and it's something that municipalities are looking at and beginning to go after nonprofits for use of property that is not tax exempt. So it'll be interesting to see, what happens there going forward. Finally, once you have the New York State tax exempt status, you will have to register as a charitable organization with the New York State Attorney General. The CHAR, I think it's 500 form, and you'll be filing that annually with your tax return. But what that basically does is the Attorney General's office will give you a registration number, and that really allows you to solicit funds, donations in New York, charitable funds. And, also in a way opens you to some scrutiny from the New York State Attorney General on the use of those funds. And that's why you have to file a form with them every year as well as your tax return, because they sort of oversee how much money you got and what you're using it for. And you have to remain in good status for that. A lot of times, the Attorney General, they also have an enforcement ability through their statute to subpoena records. And there may be, especially with COVID or when there's a disaster, a lot of people start, soliciting funds, but they're not registered to do that in New York State. So, the Attorney General's office, believe it or not, they have a whole enforcement bureau that looks at newspapers and different, emails flying around, or, so-and-so's trying to help a family, that fire burned down their house or whatever the case may be. And, they may send a letter saying, listen, there's no tax exempt status associated with your cause. Please call us because you're not registered. So another very important step there with the Attorney General's office. You will have to file taxes, tax return every year. Welcome to America. So, normally, like, again, that $50,000 seems to be the number, less than 50,000. You really only have to file what they call a postcard, and basically you're checking the box. Our income was under, that number. It's kind of an on your honor type of thing. Again, if you're filing a CHAR 500 with the AG every year and you're reporting income over than that, at some point you're going to get caught. But, we hope that people will honestly report the income and expenses of the organization on their tax return. And by the way, like, I've seen millions of the Form 990 for large organizations and smaller ones, and they're not real easy to fill out and real easy to understand. And if you make a mistake, you're submitting it to the IRS, right? So you really need to be careful with that. And I would almost say the tax professional is probably more important than your counsel, your attorney, only insofar only as they really know how to fill these forms out correctly. And just by way of, information, in these tax filings, every name and address of the board of directors, their personal address, need to be disclosed on here. So the IRS knows exactly who's involved. And of course, your social security number is associated with you as well. So a lot of times board members are interested to find out that their name and address shows up in this filing. Since 2014, another requirement, the entire board must review, understand, and approve the filing of the 990. So, it becomes an imperative that the tax professional And, a good practice, and I always, recommend it to my clients, is that the tax person attends a board meeting and walks the board through, how they arrived at the numbers and what, different questions in there mean and how they're responding. At least that way the board is educated on what's actually in the filing, and then ultimately approve the executive director or, the president, if the case may be, if it's a volunteer organization, to sign it. And when you sign a tax return, it's an affidavit. So, it's a pretty big responsibility. So what you see here is, receipts and assets of the organization require different forms. And as you grow, the tax return becomes more complicated and the requirements are larger. Just like, for an individual, maybe when you were a high school student with a part-time job, you might fill out a 1040 EZ. But now you got the house, the kids, the business, whatever the case may be. Now you're a big kid and you're filling out form 1040 to make sure you get all your write-offs and your exemptions and all of that. It's the same thing for nonprofits. So the larger the budget, the more assets that you have, real property and whatnot, the more complicated your tax filing becomes. And again, there's a cost to having tax professionals, file this. So, most volunteer organizations hesitate, to do things correctly. I hate to say it, to have that tax professional and to have an attorney that is keeping you in line, because they feel that they don't want to spend the small amount of money they do have on anything other than the program. And while I get that, there is no program unless you're in compliance. And so, again, this goes back to my first statement that it's not a hobby. You are running a business. The board of directors is legally liable for everything that happens or doesn't happen. And, I don't, in these presentations, and I've done this one for, I don't know, 7 or 8 years now, I always end by saying, this was not meant to scare you. It was meant to educate you. And if you still feel like it's something that you could do and want to do, then just make sure that you're doing it with eyes wide open. You accept the responsibility of and your legal and financial fiduciary duties. And you're going to have the budget you're going to need to hire the professionals that you need to effectively comply with all, state and federal laws, especially the IRS code. There's a lot of things you could engage in that could jeopardize your tax exempt status, and conflicts of interest in related party transactions and doing business with board members and all of that could jeopardize your tax status. Again, subject of another seminar that I do, but it can get to be a real issue for the organization. So one thing in startup mode, I always try to make sure that my clients are also aware of is really the difference between that charitable donation. For example, you want to support the Red Cross and you're going to go online and you're going to give $100. Strictly charitable, it goes to the Red Cross, their programming. I'm sure a portion of all donations go to operations because you have to be able to operate to deliver the program. But strictly charitable, you are going to get acknowledgement in the mail with the fancy language that the Attorney General requires, that most volunteers, again, don't know about. And that's going to be charitable. When you have sponsorships, it's a lot different. And this becomes a real issue. And the reason why I mention it up front is if you take one misstep and granting someone who took a sponsorship like a charitable exemption by sending a letter saying, oh, thanks for your donation, and you characterize it wrong, it could cause a problem not only for you, but for the sponsor. So, for example, let's take Acme Bank. They want to sponsor your first fundraiser, whether, let's say it's a gala, just for the heck of it. Nonprofits love their galas. And the one thing COVID-19 did was put the kibosh on that, which I think is in nonprofits' best interest anyway, but that's just my opinion. So sponsorships, if the bank wants to give you $5,000, and in return you say, okay, we're going to acknowledge you on the website, we're going to put your logo on all our invitations, and so on and so forth, the typical things. Some organizations even take out ads in large newspapers, Times Union, Business Review, whatever the case may be. It's not charitable. They're getting something back for their donation. So most businesses know this, but they'll write that off as a business marketing expense or some sort of, line item exemption for them on the business side. One of the examples I can think of is there's several banks locally that do sponsorships, and then they have with a corresponding foundation, like there's a Key Bank Foundation. And the foundation, I think the whole point behind separating it from the business itself is that the foundation does not take sponsorships. It's strictly charitable. So you're getting a grant for $5,000. They're not accepting anything in return, no recognition, no tickets to something, nothing. That is charitable. So I just always like to tell the clients up front, you need to think about what kind of gift, in the form that it's coming to you, and you need to have the finance professional that understands the difference and can book it appropriately in your financial bookkeeping system. And sometimes people give charitable gifts with a specific purpose. They're what they call restricted. And if they're restricted, you have to restrict it and use the money for that purpose. And there's a lot of accounting that goes along with that as well. As I mentioned, there are donation acknowledgement letters and very specific language for New York and most states of what has to be in there. For example, it says something like, we file our annual char with the New York State Attorney General's office, and which may be found here, and you have to put the link, among other things. So, a lot of times volunteers really are exhausted from just holding the fundraising event, and nobody really sends out a donation acknowledgement letter. If you're doing signups online and it's spitting back a receipt, you should really try to put that language somewhere on that receipt so that when it spits back to the person who just bought the tickets or the sponsorship, whatever the case may be, that they can see that charitable language is either there or it's not. And that's going to depend on what type of money you're getting. Is it a sponsorship or is it strictly charitable? So more compliance there that you need to think about. I just want to check the Q&A to make sure there's nothing in there. No. Okay. All right. So role of the board. As I mentioned, at startup, you have to have at least 3 incorporators, 3 board members to sign the incorporation papers to file with the state of New York or DC or whichever state that you're in. Strangely enough, there's issues even at that particular juncture. You really should have people incorporate that have never committed a crime or have been incarcerated. I know that sounds kind of funny, but the Attorney General has issues with board members and incorporators, that have had criminal records for obvious reasons because it's public money and we want to be careful of fraud. The Attorney General has put out some advisory opinions on how many meetings a year the board must have to properly oversee the organization. And they've said that that's 6 times every other month. I do have some clients, and I know of some nonprofits that only meet quarterly. It depends on your organization. I would never, I think quarterly is too little, but it depends on the organization. So, are you going to get a nasty gram from the AG if you're meeting quarterly? Probably not. But if something ultimately goes wrong with the organization and there's an inquiry, The Attorney General could make a finding that the board is at fault there because you weren't properly monitoring the day-to-day operations of the organization. And again, all of this is very overwhelming to that volunteer organization that has $3,000 in the bank, right? And 5 volunteer board members. And the mentality is usually, oh, we don't do all that because, it's too much, or, it's too costly. That's no excuse. The law is the law. And if you get caught, it's personal liability to the board members. Not a good idea. There goes your kid's college fund and the equity in your house. The board obviously sits in an oversight capacity. This is more important if ultimately you wind up having employees or staff. You obviously have to make sure that you have an executive director and people are properly conducting business towards the organization's mission. D&O insurance, directors and officers insurance, another startup cost. It's very important to insure the directors and officers against liability, and also perhaps in some cases their own negligence for making a bad business decision, or someone gets hurt at one of your fundraisers, or whatever the case may be. I think it's fairly cheap, but for a startup organization, it's really not. It's probably close to $1,000 a year just for directors and officers insurance, for about $1 million, $2 million of coverage, which is what you would want. And in addition to that, you really would want general liability insurance as well, in addition to that policy. So, for the first year of the nonprofit, you're probably looking at, I don't know, anywhere from $1,700 in insurance costs to maybe $2,000. And that may seem like overkill for an organization that only has a $3,000 budget at the time. But, again, if something goes wrong, it's a small price to pay for the directors and officers being insured and not having personal liability. As I mentioned, there's a ton. I've mentioned some today: financial and legal fiduciary duties that the board has to be made aware of. Oftentimes when I do the training for boards, people always walk out of there and say, when do I quit? Even people who've been doing it 10, 15, 20 years, serving on different boards, never really understood what the legal requirements say in the statutes and what can happen if they're not followed. So a lot of times, it is an eye-opener. And the more you professionalize the way you run your organization and the way the board runs it, and the opportunity for not only personal but professional development through board service, it really makes it a pleasure to serve on a board and to be part of running a business with a social mission. That's essentially what you're doing. Conflicts of interest obviously has to be worked through as a board. One of the bigger segments of my legal fiduciary duty presentation is on conflicts of interest, what they are, how to deal with them. And a lot of times the calls I get, it always makes me laugh a little bit, only because most people will call and they'll say, oh, there's a conflict of interest, and it's really not. Like, it isn't. And maybe they're erring on the side of caution, or they just don't like the fact that that board member is involved in something. I don't know. But a lot of times it's typically not a conflict of interest. Then I always get the call of, can we enter into a consulting agreement for $50,000 with one of our board members? And, then it's like, okay, red flag. Here's why. Your operations are not supposed to inure to the benefit of any board members. You have to get, comparable quotes. There's all sorts of things that you have to do to work through that. And ultimately, what you really should do is just not do business, with board members. One of the tricky things with startups, the founder syndrome, a lot of founders, I think, start these organizations and at some point feel that they have so much work into it that they should be paid. And that becomes a real problem because really you can't sit in oversight to yourself. So if you want to be paid, you should be the director and get off the board. You should no longer be the president. In fact, since 2014, the law says you can't be both. Makes complete sense, right? You can't sit in oversight to yourself. And of course, the general management of the organization, not the day-to-day, but to make sure that the organization is operating to, serve its mission, and that, your dollars and everything that you do, your staffing requirements, everything is geared toward, achieving those mission goals. Nonprofit finance and getting started, you really want to think about, and again, this isn't necessarily legal. It's just, part of my process when I represent clients. They have to think about these things in order to get their legal policies down on paper, or come to the decision that, you really need to check 2 signers on a check, or you really do need to buy the D&O insurance, and here's why. So, developing systems and document retention, that's huge. Proper risk management, with insurance, having oversight about, who's in charge of the money and how it flows. Making reports at every meeting on the financials of the board and what the current status is. And these days with COVID in particular, but anytime there's events of stress on a nonprofit organization, you really should be looking at cash flow to month and making sure you're going to meet your obligations. And then, of course, the role of the finance and audit committees. Sometimes it helps to have some training for startups, because these are folks that, being a startup nonprofit is different than going and serving on an organization that has been around for a while and has an established finance committee, and you can kind of learn the ropes that way. Startups, not so much. So, having a discussion about what their role is going to be and why you need those committees. And then, of course, how are you going to meet the requirements for filing your tax exempt 990? So, a lot to think about here. I'm happy to take any questions that you have either now or, if you want to shoot me an email later, that's certainly fine. But a lot to think about when you want to start an organization, or maybe, you have started it and now you're working towards your 1023 application. There's a lot of things you really need to get right up front, or what it's going to do is cause the state or the IRS to bounce back your application and delay really getting your organization started. And there's also, I didn't go into too much about employees and labor and employment, which is a huge area of risk management, because a lot of organizations, when they start, may not necessarily have employees right away. But, again, having the financial wherewithal to hire, professionals to help you, because labor and employment, onboarding, employees, compliance with the labor laws, it's a pretty big thing. So, again, it goes back to your why. A lot of people are passionate about a particular cause, or maybe something's happened to them in their personal life. So they want to start a nonprofit to, support spouses of veterans or children of veterans, or a scholarship of someone who died, or, something like that. And there's a lot of different ways to engage in that kind of activity without taking on all of this burden, because it's quite a burden. And, one of my biggest concerns, and the reason why I do this presentation and a lot of the presentations I do with the Law Academy pro bono, is because, my friends in the New York State Attorney General's office and I talk about this all the time. forming a nonprofit is not easy, and it's not a hobby. And a lot of folks dismiss what you really need to do and the professionals you need to hire because they just don't want to spend the money. And they say, well, we don't have that kind of money. We're just going to do this. And it causes a problem, because in the end, what's your legitimacy with your donors? Most donors these days are sophisticated. And if they're going to support your organization, some of them may even pull your 990, a previous filing, off a guide star, or they may make some additional inquiries to see if you're registered with the New York State Attorney General's office. And how have you managed that money, and have you used their money for the programming you said that you would? So, I do a lot of these seminars really just to educate people that, if you're going, and I always say to a client when they say, okay, yes, we want you to assist us with this and represent us in incorporating, I'm only going to do that for you if you agree you will get D&O insurance, if you agree that you will hire the proper, financial, the CPA or the financial firm, and that you aren't going to be looking for free services from anybody, because you really need to pay for your professionals and take it seriously. A lot of times you'll get the, well, we have an attorney on our board, we're all set. Number one, for attorneys, it's a conflict of interest for us. We should not have the board we sit on as a client, number one, even if it is pro bono. Number two, the other call I'll get is, we want you to just look over our bylaws and make sure they're compliant, because the attorney on our board says they're fine. The attorney does, trust and estates or divorce or criminal. They say they're fine, but we just want to make sure because, well, this is your practice area. And of course, when I go back to them and say, nope, not even close, they kind of shake their head. And kind of look at you with a question mark. And it's like, well, if you need a divorce, you don't call a criminal lawyer, right? It's the same thing. If you need a plumber, you call a plumber. You don't call the kid down the street, to come help you out. It's a hyper technical, environment that you're working in, and you really should not be pulling forms offline or cutting corners with having, or even a law student for that matter, the specialized information that they need to know, that they just don't know it yet because they haven't practiced. So, very important to make sure you have knowledgeable people involved. I have one question. How would you compare these New York State laws and requirements for social clubs as opposed to a nonprofit at a high level, of course? Well, a social club is organized a little bit differently. And, there would need to be some additional sections in the bylaws pertaining to social club activities. But all of this and the New York State Non-for-Profit Act applies to all nonprofits in the state of New York. So that's another great question I always get of, oh, it doesn't apply to us, we're a social club, or, oh, we're a trade association, or, oh, we're a church. Nope, it applies. So, even if you're a really small organization, with members, because usually a social club, or, maybe it's a biking club or whatever the case may be, you still have to do things properly, and you're still subject to all these requirements. And it's difficult for volunteers to manage all this and to make sure that everything is, as it should be. But I will say, at least from the startup component, if you've started up correctly, you might only need to revise your bylaws and maybe add a conflict of interest policy later on to become fully compliant. You may not need to do a whole heck of a lot to make sure that you're now complying with the laws of 2014. A lot of it's governance. For lately with COVID, everybody's online and they're holding meetings via Zoom, which is fine. But going back to the email piece, technically, even as the law sits there today, there's no statute that says you can take an email vote. What it says is that you can pass a resolution by unanimous consent of the board. And what that means is that when, in the way I tell my clients to do it is, you have your resolution for whatever you're asking them to pass, and you send that out to the entire board through their email. It has to be unanimous. So not only does everyone have to respond, but they have to respond with, I approve, I'm giving my consent to this resolution. So technically it's not even a vote, they're just consenting to the action. If you have a board member who doesn't respond, if you have a board member who doesn't use email, and that still is an issue these days, some older members just refuse to do it, or if a discussion starts in that email, then the vote's dead. I mean, it literally, the whole point behind what the statute says now is that the AG wants you having an actual meeting and discussing all these things on the record together, face to face. So really, the unanimous written consent should only be used, in an emergency. If it's something simple, and I'm trying to think of an example, it's escaping me, but these are the type of things that apply to the smallest of the small organization, but also the largest of the large. The law is the law. And the reason why the AG and the legislature really updated it in 2014 is because there was too many small nonprofits not doing what they're supposed to be doing, and no regulation of the use of that public money. So, I guess, from a high level, there really is no difference, regardless of what kind of nonprofit that you're running, whether it's a social club or a hospital or a college or, a church ministry, whatever the case may be. It's the same. It's the same for tiny little nonprofit you started next week and big nonprofit Red Cross. And a lot of people are critical of that because it doesn't seem necessarily fair. But as you can see from some of the things I've mentioned today, most board members would not know any of this. So that's the whole point, is that, if you're going to be a board member, you need to stay on top of this type of thing and make sure things are done correctly, because it's your liability if you don't. And then the $1 million question I always get, and I love it because it gives me a chance to say, here's how they'll get you. But I'm always saying, have that one person in the room, or, in an email, they say, well, what happens if we don't do it? And that's always interesting, because that leads me to the conclusion of a few things. One, that person should not be on a nonprofit board, and probably just violated their fiduciary duty in the statute, the duty of care. Number two, they probably don't realize all the tax filings and the filings with the AG that the organization has to do, disclosing their activities and their expenditures, that are reviewed and audited. They're probably not thinking about that donor who complains that the money that they gave wasn't used for what it was supposed to, and now they've just made a complaint to the AG's office. Now the AG office sends you a nice little letter and says, we're going to audit everything you're doing. Or the IRS reviews your 990 and sees that, you're doing some activity that could be unrelated business, not the mission of the organization. Somebody else could, this is a perfect example. Even 2 weeks ago, I got 2 calls. Nothing's a problem until it is, right? So this organization, small, was pledging along, no big deal, day in, day out. And then one of the board members got annoyed with one of the decisions the board made and said that, they didn't think it was legally something that they could do. And they did. They went to the Attorney General's office. So not only are they looking at that particular issue, but now they're going to look how you're doing everything. And usually if there's one issue, there's many. So the chances of, you know, for you getting caught for not filing these or doing the filings or disclosures you need to do, or not operating correctly, can come back to really haunt you in certain circumstances. You know, and again, I always advise my clients that reasonable or substantial compliance is the bare minimum. You know, you do the best you can. You know, if you really can't get that board together to take the vote, then okay, use the unanimous consent. But if you do that, then you better make sure you do it right, right? Because otherwise that unanimous consent is no good and you shouldn't have sold that property, right? So, you know, it is really important to do the best you can. And if you're not sure, call your professionals and say, what do you think? As long as your board is informed, the courts and the legal standard is the business judgment rule. As long as you made the best decision you could with the information you had available, and you're allowed to rely on professionals, then you're good. You know, your insurance will kick in and protect you if you've taken all those steps. So I hope that answers your question, Deborah. Okay, so that's it for the questions. Like I said, I hope this is helpful. I hope you're not too scared. It is not meant to discourage you. It's meant to just help you understand what you're getting yourself into. If there's anything else that you'd like to talk about, you certainly can send me an email or give me a call. All right, thanks everyone.